What does a dismissal without prejudice statute of limitations for a felony in Oklahoma look like, or is it always open? I'm Tulsa Attorney James Worth, and that is the question that we have. What is the effect of a dismissal without prejudice related to refiling for a felony in Oklahoma? Okay, so first off, I want to talk about civil cases. Now, obviously, the question here that we received online deals with a criminal case, specifically a felony case, but I want to talk about civil in order to differentiate the two. Okay, so in a civil case in the state of Oklahoma, if there is a dismissal without prejudice to refiling, that means that you can refile it. If it's with prejudice, that means you can't refile it. And in Oklahoma, for civil cases, there's a saving statute, which says that it can be refiled anywhere within 1 year from the dismissal. So if it's dismissed without prejudice in a civil case, you've got at least 1 year to refile that to keep it alive. Now, if the statute of limitations is longer than that, then you may be able to file it longer than that. But even if it is outside of the statute of limitations, as long as you refile within a year of the dismissal without prejudice, then you're safe. However, you can only use that saving statute one time. Okay, so that's the civil code, but here we're dealing with felonies. Okay, we're felony law in the state of Oklahoma for criminal defense, or I should say criminal procedure. There is no saving statute. So if a criminal case is dismissed without prejudice, that means that the prosecutor can refile it, but the limitation on that is the original statute of limitations. It's not extended by any saving statute. So whatever the original statute of limitations is, which usually starts based on the date the crime was committed. And typically in the state of Oklahoma, most statute of limitations are 3 years. There's a statute that lines them all out. It's a Title 22, Section 152, and it has a listing for various crimes in the statute of limitations, and it has this catch-all provision in subsection H, which says, in all other cases, a prosecution for a public offense must be commenced within 3 years after its commission. So that's the default. That's what most crimes are. Arson, for example, under here is 7 years. If it involves a deadly weapon, then it's 7 years. If it's fraud, it's anywhere from 3 years to 7 years, depending on when it was discovered. For false, bogus checks, it's 5 years. If we're talking about sexual crimes against children, then it's up to the 45th birthday of the alleged victim. So that is what the various statute of limitations are in the state of Oklahoma. As far as refiling, no saving statute. So if the prosecution is going to refile a criminal case after it's dismissed without prejudice, it must be done within the time frame of the original statute of limitations. All right, if you've got a question related to criminal procedure in the state of Oklahoma, you're dealing with a case, or a friend or family member is, you're probably going to want to talk to an attorney privately and confidentially to get legal advice. To get that scheduled with an attorney at my office, you can go online to makelaweasy.com.